I'm very honored and excited to make a presentation about Aboriginal Indian title because I think there's a general ignorance of Aboriginal Indian title. I'm motivated in part by an experience I had quite a few years ago, attempting to negotiate a culturally and economically adequate land base for the Western Shoshone Nation in Nevada. We were negotiating with staff from Senator Harry Reid's office and had several meetings with that individual, who I should say that was an unsuccessful negotiation. And that individual subsequently published a scholarly article in a law review purporting to detail the history of the public lands in Nevada. The article didn't include the word Indian, so that part of the history of public lands in Nevada was entirely left out. I note that Indian title is the origin of all land titles in the United States. And many of you are familiar with the concept of chain of title. If you're going to buy a property, you want to know that there's a sound chain of title from A to B to C to U. What I'm talking about is item A, the very first title in all chains of title in the United States. So Indian title is a fundamental doctrine of Anglo-American property law. And a chain of title is a fundamental part of that as well. Where we've got the slide. Can we go to slide 2? Okay, great, thanks. I want to mention the 1894 Utah Enabling Act, which converted Utah territory into the state of Utah, and it disavows state jurisdiction and ownership of all public lands in Utah. I also want to note, however, that Utah is not claiming that it's in the chain of title. It certainly isn't. It's making what I would characterize as a kind of states' rights constitutional claim, which John Leshy and John Ruppel will discuss in more detail. Next slide. Okay, this is I see there's a monitor here I ought to be looking at. This is a map of acquisitions by the United States over time, and I call your attention to the gray area, which is the southwestern United States, and is everything west of the Rio Grande, with the Rio Grande projected north to the Utah-Idaho line. And of course, that includes the state of Utah. Next slide, please. This is a map prepared by Charles Royce and published in 1897 from the Smithsonian Bureau of American Ethnology. And we don't have time for me to talk about each of these numbered areas, but I want to call your attention to the yellow area on the north, numbered 444 and 520. And as nearly as I can figure, that is, with one exception I'll discuss later, the only part of Utah that tribes ever ceded to the United States, and that was in a treaty with the northwestern bands of Shoshones and Bannocks. I also call your attention to the gray-green area, 432, and the pink area on the east, 515. Those areas were ceded by the Utes to the United States in the Spanish Fork Treaty of 1865. However, it was not ratified, so no cession was effective. Area 431, I hope you can see these. Can you see the numbers? Okay, great. Area 431 was the Ute Indian Reserve as it existed in 1897, and I haven't studied that in detail, but I think it may have been substantially reduced by subsequent agreements. Next slide, please. Okay, this is the Utah portion of the final map of the Indian Claims Commission published in 1978. and it shows the areas of Indian lands which were adjudicated by the Indian Claims Commission and for which awards were made by the Indian Claims Commission for a taking of those lands. And you can see that a good bit of the area of Utah was not adjudicated by the Indian Claims Commission, although there was Aboriginal Indian title in those areas. So next slide, please. So why is Utah named Utah? When the state makes claims against the public lands, I think that question comes up. And what I found was a 1994 Deseret News article to the effect that Utah is an anglicization of the word Utah, which was Spanish, the Spanish word for the Utes. And in the opinion in Utah, Ute Indians of Utah versus U.S. from 1993 in the United States Court of Federal Claims, the court says that Utah Indians refers to any and all Indians resident in Utah. Next slide, please. This is part of the language of the 1894 Utah Enabling Act creating the state, and I've highlighted the language where it says that the residents of Utah agree that they forever disclaim all right and title to the unappropriated public lands and to all lands lying within the limits of Utah or held by any Indian tribe or Indian tribes. Next slide, please. I want to talk about the origin of Aboriginal Indian title. And incidentally, this area of the law is much more complex than I'm presenting, but time constraints required me to kind of try to boil it down. Aboriginal Indian title has its origins in Spanish colonial law because Spanish colonial law acknowledged a land tenure on the part of indigenous peoples in the New World and to some extent attempted to protect that indigenous land tenure. Congress passed an extremely important act in 1790, which was reenacted in 1834, called the Indian Non-Intercourse Act. And it implements a very important policy of the United States asserting that it controls Indian land and Indian title, and there can be no transfer of that title to private parties or to states without, as the Act says, by federal treaty or convention, meaning the federal government has to be part of that transaction or agree to that transaction. So any direct private purchases or unauthorized cessions to states are invalid, and that's been litigated. A very important case is 1823 Supreme Court decision in Johnson v. McIntosh, which adopts the doctrine of discovery, the notion that when European nations, quote, discovered lands in the New World, they acceded to sovereignty and to ownership of the land. And that Supreme Court adopted that doctrine here in Johnson v. McIntosh and held that the federal government holds the underlying fee title to Indian lands, or what the court called absolute ownership. But that title is, however, subject to an Indian right of occupancy, which is what we call Indian title. In 1831, the Supreme Court decided Cherokee Nation v. Georgia, which says some important things I won't cover, but I took this snippet of language out of it, that the court says Aboriginal title is, quote, as sacred as the fee simple of the whites. That's a big statement, and it appears in quite a number of Supreme Court decisions. So how do you get in Aboriginal Indian title? How does the tribe get it? Well, the courts have said, and I should say that all of this doctrine of Aboriginal Indian title, except for the 1790 Act of Congress, is federal common law created by court decisions and court precedent. And they have held that Indian title is created by continuous, exclusive tribal occupancy for a long time. and one court has held that that's as little as 20 years. Next slide. Actually, I can control those, can't I? I should be doing that. What is the nature of Aboriginal Indian title? The United States can convey the underlying legal title, and of course it's done so by patents. And those patents, the land subject to those patents continues to be subject to unextinguished Indian title. So those areas include original grants by the United States, of which there are some, railroad grant lands, which cross the western United States, and homesteads and mining claims. Now, I don't know what the basis of private titles is in Salt Lake City, but I'm very interested in that. I don't think it's homesteads. So, how is Indian title extinguished? Once established, Indian title is good until it is extinguished by really only one of three things. Either the tribe cedes the land to the United States in a ratified treaty, or there is an act of Congress which specifically extinguishes the Aboriginal Indian title to a specific tract of land. And that statutes like the 1891 Forest Reserve Act and the 1934 Taylor Grazing Act do not meet that standard. Indian title was not extinguished by the creation of the national forests or the Taylor grazing districts. Or lastly, intentional abandonment by the tribe. And the Utah Uinta Utes went to the Federal Court of Claims and obtained a decision in 1993. They were litigating concerning, it gets a little complicated, but their interest in the land of Fort Douglas, which the federal government had conveyed, I think, to the university. And the court held that there was an abandonment of those lands, so it's intentional abandonment. We litigated the case of Pueblo of Jemez versus United States, and we have two 10th Circuit opinions about that, and it is a very important precedent for Aboriginal Indian title. We established, through proof, of course, in the trial court, that the tribe, the Pueblo, had established its Aboriginal Indian title as of 1650, would you believe, during Spanish colonial times, and that title is still good. It was never ceded and enforceable against the United States because there's a loophole in the Quiet Title Act, which I'll discuss in a moment. Let me see here, next slide. Did I go the wrong way? I want to talk about important Indian treaties in Utah. The first one is at the 1863 Northwestern Bands of Shoshones Treaty of Box Elder. At that time, the United States was trying to cross Indian land to get to California to get gold to finance the Civil War, and they didn't want to fight Indians on the way, and they didn't want to have to take care of them. So all they wanted was rights of way, and this treaty gives them rights of way, but it does not cede land. Similarly, with the Western Shoshone 1863 Treaty of Ruby Valley and the 1863 Goshute Treaty, no cession. The 1865 Southern Paiute Treaty did cede land, except it was never ratified by Congress, so there's no cession there either. In 1868, the Shoshones entered into the Treaty of Fort Bridger, and that ceded the northwest portion of Utah, which you see in the map on your right as the yellow area at the top of the map. As nearly as I can tell, with the exception of the yellow area at the bottom, which is Navajo, Aboriginal Indian title lands in Utah have never been ceded or extinguished. There was also the 1868, well, I mentioned the 1868 Treaty of Fort Bridger, where the Shoshones ceded the land. They didn't cede it in the 1863 treaty, but they ceded it in the 1865 treaty. And then in 1868, there was a Ute treaty, which only ceded Ute lands in Colorado. It did not involve Ute lands in Utah, which were held by the Utah Uinta Ute Band, now on the Uinta and Ouray Reservation. But they were a separate tribe at the time, and so the area you see in gray on the map and to the east was never ceded by the Utah Uinta Utes. Lastly, there's the 1868 Navajo Treaty, which did cede that yellow area in the southwest corner of Utah, but the Navajo Nation subsequently recovered that by act of Congress, and it's now the Aneth Extension, it's called. So I want to talk about the Indian Claims Commission, and I forgot to keep track of time here, so give me a signal, Kirk.
Okay, I think you have 3 or 4 more.
Excuse me, yeah, okay. The Indian Claims Commission was established by Congress in 1946, and it was established because tribes had been bringing claims against the United States, but they had to do it by special jurisdictional act. They had to go to Congress and get a special act every time, and there are dozens of those. Congress got tired of it and decided that they'd create this commission to handle claims for compensation for takings of land and for what the legislative history characterizes as ancient wrongs. The ICC adjudicated those claims with an appeal to the Federal Court of Claims up until 1978, when the commission was terminated and published the map that I showed earlier. And there were remaining claims passed on to the Claims Court, which went on well into this millennium. The Congress did not want to appropriate a sum of money to pay attorneys to represent the tribes in the Indian Claims Commission, and the tribes were mostly impoverished at that time and couldn't pay attorneys. So it provided for up to 10% of an award as a contingent fee to the attorneys. Unfortunately, that created an incentive for the attorneys to try to prove the loss of as large Indian assets as possible. And in that process, they asserted claims for takings which never happened. And in the case of the Western Shoshones, I haven't checked the Goshute language to see exactly what they say there, but it's basically the same thing. What the court said in the Western Shoshone case was that the Shoshones lost their title by gradual encroachment of whites, settlers, and others. They were deprived of their lands. And you might notice some peculiarities about this. For one thing, it doesn't fit into the Anglo-American property law system whatsoever. How could settlers on Shoshone lands give the United States title? Does not fit the concept of chain of title. And also, what's deprived of their lands mean? Is that a conveyance? Not hardly. So that same approach was used in the Goshute case and in the Southern Paiute case. There is a finality provision in the Indian Claims Commission Act which says that upon payment of the Indians, there shall be no further claims against the United States touching any of the matters adjudicated. Well, notice that that protects the United States. It doesn't protect private parties or states, for that matter, where you can get past the state sovereign immunity. But the Ninth Circuit Court of Appeals has interpreted that very broadly, so it does protect private parties, but that's not the case in the Tenth Circuit. So what is the status of Indian title in Utah? Well, Utah was 100% Aboriginal Indian title when the Mormons settled Utah. The Shoshone Bannock ceded that yellow portion of northern Utah in their 1868 treaty. The Western Shoshones, Goshute, Southern Paiutes, and Utah Uinta Utes never ceded any land, but they all received ICC awards for takings of land that didn't actually happen. In the Western Shoshone case, since they had no date of taking, the attorney stipulated that it was July 1, 1872. And when I'm explaining this case to Western Shoshone audiences, I like to make the point that, or ask, what do you suppose was happening on July 1, 1872? Mostly what we know is it was a hell of a hot day, and there were hardly any white people around. That was it. So I think there are tribal live title claims for the Shoshones, Goshutes, Utes, and Southern Paiutes in Utah, although they are precluded as against the United States by the ICC finality provision. They're also foreclosed with a loophole by the 1872 Federal Quiet Title Act, which has a 12-year statute of limitations in it, and the federal government asserted control over all of these public lands in Utah much earlier than 12 years back from, say, today's date. So that provision bars claims against the United States. Although, if the United States acquires a parcel of land, as it did in the Hamas case, the United States purchased a very large private grant in the year 2000, and the Pueblo of Hamas filed within the 12-year statute of limitations time in 2012 and was successful. So there's no statute of but there is no statute of limitations for Indian title claims against private parties. So to conclude, Utah has no property right claim to federal public lands. If anyone has a better right than the federal government to the public lands in Utah, it's the Indian tribes. To the extent that the federal government actually acquired title to Utah public lands, it was by coercion and, in effect, fraud through this takings notion that the takings that never happened, practiced on the tribes. So I like to say sometimes that the government forgot to steal the land, which they could have done by express act of Congress. So arguably the Shoshones, Goshutes, Southern Paiutes, and Utah Uinta Utes hold unextinguished Aboriginal Indian title to their ancestral lands, but they are precluded from going to court in most instances. So you can say they have rights, but they don't have a remedy, although the notion of a right without a remedy is not supposed to exist in Anglo-American law. So thank you very much. That's the quick précis of what's happening with Aboriginal Indian title.